Greetings. Today we're going to talk about control of public schools, and that will include attendance and immunization, transportation, homeschooling, and curriculum. But first I want to give you another legal term, and that's parens patri. Parens patri means the state is the parent of us all. And what this does is it says that the state's needs can supersede that of a parent. So, for example, this might come into play in the courts if a parent is failing to compel their child to go to school, even if they say they don't want their child to go to school, or if their child isn't getting necessary medical attention, then the court can step in and order the parent to do what is necessary or whatever is stipulated in that event. So that's an example of parens patri. So now let's talk about attendance. We know that attendance, as your book said, is a school and state prerogative, with the stipulation that states and schools cannot discriminate against special groups. For example, those students with special needs or illegal aliens or those that are homeless. And you may hear some school administrators sometimes say, I don't want to pay for students who aren't paying their taxes because they're here illegally, but that doesn't matter because the state's desire and prerogative is to have a well-educated citizenry, and that supersedes that your feelings as an administrator. So all the student needs to reside in a place is to reside in that place, even if they don't have proper documentation. So be very clear, even if they don't have proper documentation. So let's talk about residence. To establish a person's residency, a person must be physically present or have the intent to stay. So the Supreme Judicial Court in Maine actually established in 1857 a definition which said that the person has to be physically present, and that's used across the country. And in the U.S. Supreme Court now defines a domicile as a person's true place of habitation. So schools should admit students who are staying with relatives, even if they don't have legal guardianship, so that the students aren't kept out of school. A lot of times administrators use the law in ways that they shouldn't, saying you have to have legal guardianship for us to allow the student in the school, but that's just not the law. So this helps in cases where parents are absent or they've given over guardianship, but yet the child is where they haven't yet given it over, but yet the child is truly residing with somebody else like a grandparent. So also related to attendance is that states can impose age restrictions. So Connecticut says that students must go to school between their 5th and 18th birthday, but it also allows parents to keep their children home until they're 7 years old by the parent going in and filling out an option at the school district. So some states, like for example Georgia, they say compulsory education is only between the 6th and 16th year, or 6th and 16th birthday. And other states still say you don't have to go to school until your 7th birthday, even though they have pre-Ks and kindergartens. In that case, the state can't compel a student to go to school until their 7th birthday, even though those services are available. So compulsory education or attendance, is interesting because in all states, it's the parent's responsibility to get a child to school. So if a child is truant, the courts don't come down on the child, they come down on the parent. The problem with truancy laws in a lot of places is that there's no teeth. You fill out all those reports, at least we did in Maine, you send them to the state, and then nothing ever happens, and the courts rarely get involved. And so that's a real challenge with truancy laws. As you may know, truancy is defined in different states differently, but here in Connecticut it's defined as 4 unexcused absences or 10 in a school year. So if you miss 20 in Connecticut, unexcused absences, you're defined as habitually truant. In Connecticut, the school is required when the student is truant to meet with the parents or guardians within 10 days of the student becoming truant. And if the parent or guardian doesn't show up, or if the school feels the student isn't being supported to come to school, then the school can refer the matter to the court through the Families with Service Needs Law. And then this case is assigned to a probation officer who meets with the families, and depending on how that goes, they can refer the case to the court or simply to a family support center. So, although the courts can't arrest students for truancy, if a student in Connecticut disobeys a judge's order, if it does go to a court, then the student themselves can be placed in a facility for up to 45 days. So let's talk about immunization. All states have immunization requirements, and Connecticut is not an exception. All students must be vaccinated against certain diseases, But in Connecticut, you can get exemptions. And one of the easier ways to get an exemption is through religious exemption. You can present a written statement to the school that says it's against your religious beliefs, and the school has to honor that. Another way is to get a medical exemption through a physician who says that maybe it's not in your child's best interest because of health reasons. So many states, and Connecticut is one, has a provision that if you are in school and you're not vaccinated when there's an outbreak, the school can send that student home until the outbreak is over. So now let's look at homeschooling in Connecticut. Like every other state, Connecticut does have provisions to homeschool students. Courts have allowed this across the country, and courts have also allowed that states can set up their own reasonable provisions for homeschooling. For example, even though in Connecticut you don't have to notify a government official that you're homeschooling a student, your homeschool instruction must include certain components of the curriculum, like reading and geography and math and social studies, for example. Some districts require that when returning from homeschooling, the child must take a standardized test just to know where to place the children when homeschooled. So let's move on to transportation. Connecticut schools do receive some state funds for transportation, and the state laws say that law requires school districts to provide transportation for all children whenever it's reasonable and desirable. So the states can set their own walking distance to and from school, who will be picked up and who won't. So that's up to the state. And this isn't so in every state, meaning there's not funding in every state. There are a lot of urban places where students are responsible for getting themselves to school, either by public transportation or through a transportation voucher, especially for those with free and reduced lunch. Some states actually charge school parents or guardians specifically in transportation, which is tough, but given that we're in tough budget times, that often falls to the chopping block. Finally, I want to talk about curriculum a little bit, and we'll talk a little bit more about curriculum and freedoms that go along with it as we go through this course. But it's really clear, especially in the new Every Student Succeeds Act, that parents have to be involved in curricular decisions. So parents should be on committees for selecting books, for curriculum. And certainly I know the school board is made up of parents, but we want to be clear that a parent does not have the right, even if they are on committees, right, to come into the school and say, for example, that a book they demand that it be removed from the library. Courts have consistently ruled on something they call a marketplace of ideas, which just means that they want students to have exposure to more ideas and more theories and more ways of thinking on a topic than fewer. So the parent doesn't have the right to say, I don't want my son, or they do have the right to say, I don't want my son or daughter to read that book that's in the library, but they don't have the right to demand that it be removed. Certainly many districts make provisions if there's something being taught in a class that parents object to. A lot of schools provide an alternative assignment, but as I said before, parents can't demand the curriculum be tailored simply to meet their beliefs and preferences. Okay, I look forward to seeing you again.